Hello, 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 it's Attorney Mike Gravel coming to you from beautiful Budapest, Hungary. And I posted a few sovereign citizen videos. I got them from a small channel, so I need to look real quick. I need to give them shout outs. Truth 24 Judgment and at Basketball Central 65. Thank you. These are just fun. I missed them. They're good stuff. Let's do it, shall we?
Mr. Azultine, I may be pronouncing that wrong, is a fairly recent warrant. I would be we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction. And I have some questions before I feel comfortable with this court moving forward.
Oh,
Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here. And I'm hearing a lot of nonsense that doesn't.
I always like this judge, but he's obviously tired of this crap altogether. We're not addressing anything until you admit who you are, which is the exact appropriate thing to do.
Address directly that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or
Well, he's not represented by counsel and hasn't been throughout this case.
he's refused counsel.
Yep. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
Yep, I'm in Andrew time here.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash.
Perfect. Big dummy, come in personally next time.
All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
Case number 24 RO04189. This is people of the City of Royal Oak versus Anthony Winston.
How am I missing all these nuggets? How am I missing them? I don't know. They might be ancient or whatever, but they're new to me. I haven't seen them.
Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
Mr. Mathis, today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, near Washington, in the City of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances.
What the hell are you North Americans doing up?
Or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
Let's solemnly swear the testimony you shall give before this court shall be the truth, so help you God.
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge black in color with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
And that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. Or you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf of the city?
I guess he wants them to drag in the actual physical city and plop it on the witness stand.
Royal Oak.
Where is the city of Royal Oak?
Certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
That's failure. I like the close. That's failure. That just says it all right there. No, you're a failure. But this case is going along just great.
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case
Why are you
under
trying
the
to
Motor
charge
Vehicle
me?
Code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
Very
no,
well, $175 that is payable
I
through
would
the
not-
pay portal
no, I
on
would
the
not-
44th
I would
District
not
Court
be-
website, or
I
you may
bet
walk
I
a
would not be
cash
paying
check or
any fine.
charge into the
I would not be
44th
paying
District
any
Court.
fine.
Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank
Oh, isn't he special? All right, I got one more. We got another sub who tries it in a civil context. It's just as fun.
Pre-trial, no appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308 signed, and then it was a
I like how she took the time to actually visually display his stupid.
return to sender, Judge.
All right,
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do.
You can refuse to accept it if you want, but you're going to eat the consequences, my friend. This judge is fun.
One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. By open written discovery in this matter, you have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me. See what you're talking
I
about?
wasn't finished. I wasn't finished. She
All right,
cut
I'm going to
me
mute
off.
you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
gonna
I was
have this.
still talking.
This is not a clown show.
Oh
You will
my
speak
goodness.
One at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted
You just said you don't understand anything, which I believe that.
me about the alleged debt. I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if
Yeah, because you didn't answer your mail.
they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right.
Well, you already contracted with them when they were handing out credit or money. You made a contract, and they've got it all figured out, and you're losing.
Let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you.
Question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the packet. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question.
Oh.
Do you, should they have sent me something before they sending me this package since the last court date
Sir,
to verify that?
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's gonna send me a packet and I'm gonna send her back a packet as well, right?
No, you're gonna do what you choose to do. She's gonna send you again those requests for admissions.
Well, you said the
Don't
discovery.
interrupt me again.
for me
We had
and
this
her.
conversation before, didn't we?
Sorry,
We
Go
had
ahead.
this conversation before.
go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial, your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
All right.
I do hereby reserve all of my rights, waive none, not to be compelled to perform under any contract or
Yeah, no one cares.
commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the
You probably entered into it in writing.
liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay, let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
Was that?
It looks like this.
Yeah, I'm asking
Yeah.
you, if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay, so let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay, July
Thank
26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent?
Okay, I didn't even appreciate this first time. This is the dummy SovCits. Issuing a request to admit to the plaintiff. Asking the plaintiff to admit the elements of their case, which is exactly what they're trying to prove. And you can admit them by simply not responding to them. The judge is having fun with this. Oh, this is good. I didn't notice that subtlety.
Had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contained or contains no elements of fraud by Credit One Bank. The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He's failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff.
Well, there you have it. That was too much fun. There's 3 SovCits that I've never streamed. I saw from the chat that last one was old, but it doesn't matter. That was top quality. That was top quality stuff. The other 2 are fantastic as well. I don't know the age of those. I don't know the age of those, but it doesn't really matter. I'm doing the best I can with the time gap that I have. I was going to try to, and you're asking about Lori Vallow. No, I haven't been following Lori Vallow specifically because I know I'd be traveling, and I can't. Like a full trial, like it's like that. I can do a stream for an hour a day or something, and it's really fun. But I'm not gonna come over to Europe and stream a trial for 8 hours a day. I'm just not doing it. I did it for a couple days in Rio, and I was mad at myself. I didn't mean to. These are the issues I have, people. who I might deal with is today. We're supposed to have an arraignment for old crazy pants there. What's it? The tonsil twins, whatever the hell her name is. The woman who went after Mr. Eckert. But I don't know if that's going to work, and I'm not sure if I'm going to be in a place to stream when it happens anyways. But if I can, or if it's fun, I'll just do it late anyway. Because I did want to see that. Laura Owens, there we go. Laura Owens. That should be fun. I had a bunch of people trying to help me find the link. And also everybody sent me the police report, and they show up, and of course she's a complete drama queen. The police report of them arresting her with the charges. She's in the casita next to her mom and dad. She won't come out. Yeah, I can see the whole thing. I think there's a movement to get that body cam footage. I'm sure it's straight Karen top to bottom. I'm sure it's all straight Karen. That's good stuff. If I can get a hold of that clip later, I might do it. Who knows? But anyway, thank y'all for coming out. I know this is a real weird hour for the U.S. folks, but it works out great for the Europeans and the Aussies and the Kiwis. All right, thanks for coming out. I'll see y'all soon.